The Supreme Court just issued what looks like a devastating blow to state-level Second Amendment resistance. In an 8-1 decision, the court denied Missouri's request to protect its Second Amendment Preservation Act, and within minutes, headlines across the country declared the law effectively dead. But if you look closely at what the court actually did, and just as importantly, what it did not do, you'll realize this ruling is being widely misunderstood. Because despite the dramatic headlines, the Supreme Court did not rule that Missouri's law is unconstitutional. They did not strike it down. They didn't even hear arguments on whether the law violates federal authority. What they issued instead was a procedural decision, one that raises far more questions than it answers and sets the stage for a much larger constitutional showdown still to come. To understand why this matters, we need to slow down, strip away the noise, and walk through exactly what this 8-1 vote means, how it happened so quickly, and why the court's silence may be more important than the vote itself. Let's start with the basics. Missouri's Second Amendment Preservation Act, often referred to as SAPA, was passed in 2021 as House Bill 85. The law was designed to do something no other state had attempted at this scale. Instead of simply declaring support for the Second Amendment or symbolically condemning federal gun regulations, Missouri took a far more aggressive approach. The law declared that certain federal firearms regulations exceed the federal government's constitutional authority, and that Missouri would not assist in enforcing them. But Missouri didn't stop there. The law explicitly barred state and local officials from participating in the enforcement of federal gun laws that the state deemed unconstitutional. That includes providing manpower, funding, facilities, equipment, or logistical support. If federal agencies wanted to enforce those regulations inside Missouri, they would have to do so entirely on their own. And then came the part that triggered alarm bells in Washington. Missouri created a private enforcement mechanism that allows any Missouri citizen to sue state or local officials who violate the law by assisting federal gun enforcement. The minimum penalty, $50,000 per violation, plus attorney's fees. There is no cap. That enforcement structure wasn't accidental. Missouri lawmakers openly modeled it after Texas Senate Bill 8, the abortion law that survived early court challenges precisely because it relied on private citizens instead of state officials for enforcement. Missouri's message was clear. If this structure could shield abortion restrictions from immediate judicial review, it could be used to protect Second Amendment rights as well. The federal government did not agree. In March 2022, the Department of Justice sued Missouri, arguing that the law violated the Supremacy Clause of the Constitution by attempting to nullify federal law. The case landed in federal district court, where Judge Brian Wines issued a sweeping preliminary injunction blocking the entire statute from being enforced. The injunction was broad. It barred Missouri, its officers, agents, and employees from enforcing any part of the law and prohibited anyone acting in concert with the state from doing so. In practical terms, it froze SAPA in place before it could fully operate. Missouri appealed, but both the District Court and the Eighth Circuit Court of Appeals refused to pause the injunction while the appeal was pending. That left Missouri with only one option, an emergency application to the Supreme Court. This is where the story starts to get distorted. Emergency applications are not full Supreme Court cases. There are no oral arguments. There are no lengthy written briefs. The court is not deciding whether the law is unconstitutional. Instead, the justices are asked one narrow question: should the lower court's injunction be paused while the appeal continues? That's it. And in this case, by an 8-1 vote, the court said no. Justice Clarence Thomas was the lone justice who voted to grant Missouri's request. Chief Justice Roberts and 7 other justices voted to deny it. No majority opinion was issued. No explanation was required. To casual observers, that looks like a landslide rejection. 8 justices against Missouri. End of the road. But that conclusion assumes something the court never said. The Supreme Court did not affirm the lower court's ruling. They did not endorse the district judge's reasoning. They did not rule that Missouri's law violates the Supremacy Clause. All they decided was that they were not going to intervene at this early stage.
That distinction matters enormously. When the Supreme Court declines to step in on an emergency basis, it often signals that the justices want the lower courts to fully develop the record before they weigh in. Emergency relief is extraordinary.
It is not granted lightly, especially when a case involves novel constitutional questions with nationwide implications. And Missouri's law is unquestionably novel. It sits at the intersection of federal supremacy, state sovereignty, the anti-commandeering doctrine, and the Second Amendment. The court has repeatedly held that states cannot be forced to enforce federal law. At the same time, it has never sanctioned a state law that actively penalizes state officials for cooperating with federal authorities. That tension is precisely why this case matters. Missouri argues that it is simply exercising its right to refuse cooperation under the 10th Amendment. The federal government argues that Missouri went much further, creating a regime designed to intimidate and obstruct federal enforcement. Those questions are not easy, and they are not the kind of questions the Supreme Court typically resolves through an emergency docket order. So, when the court declined to pause the injunction, it did not close the door, it left it open. And yet, most coverage stopped there. What almost no one mentioned is that this order came without any ruling on the merits, and without any indication of how the justices ultimately view Missouri's law. That silence is not accidental. It reflects a court that is, at minimum, unwilling to rush into a decision that could reshape the balance of power between states and the federal government. But that's only part of the story, because buried within this denial is something far more consequential than the vote count itself, something that fundamentally changes how this order should be read. And it comes from two justices who technically voted against Missouri. Justice Clarence Thomas was the only justice who voted to grant Missouri's emergency request. He did not write a separate opinion explaining his reasoning, but his vote alone sends a powerful signal about how at least one member of the court views this case. Thomas has long been the court's most consistent defender of both state sovereignty and Second Amendment rights. His jurisprudence is grounded in the belief that the Constitution establishes a dual sovereignty, one in which states retain meaningful authority to resist federal overreach. That philosophy sits at the core of Missouri's argument. At the heart of this case is the anti-commandeering doctrine, the principle that the federal government cannot force states to use their own resources to enforce federal law. This doctrine is not fringe, it is settled Supreme Court precedent. In cases like Prince v. United States and Murphy v. NCAA, the court made clear that Congress may regulate individuals directly, but it cannot conscript state governments into carrying out federal policy. Missouri argues that its Second Amendment Preservation Act is simply an extension of that doctrine. The state is not blocking federal agents from enforcing federal law. It is not interfering with federal prosecutions. It is merely refusing to help and penalizing state officials who choose to help anyway. From Thomas's perspective, that distinction likely matters. Thomas has repeatedly emphasized that states are not subordinate administrative units of the federal government. In his view, when federal regulations exceed constitutional bounds, states retain the authority to withdraw cooperation. That view aligns closely with Missouri's theory of the case. The timing of Thomas's vote also matters. Just months earlier, Thomas authored the majority opinion in New York State Rifle and Association v. Bruen, one of the most consequential Second Amendment decisions in modern history. In that case, the court held that gun regulations must be consistent with the nation's historical tradition of firearm regulation. That ruling dramatically reshaped Second Amendment jurisprudence and placed many existing federal and state regulations under constitutional scrutiny. If Thomas believes that certain federal gun regulations cannot survive Bruin's historical test, it follows logically that he would be sympathetic to a state attempting to distance itself from enforcing those regulations. But Thomas was alone. Chief Justice Roberts and the other conservative justices who joined him in Bruin were not willing to intervene here. That fact has led many commentators to conclude that the court has rejected Missouri's strategy outright. That conclusion may be premature, because two justices who voted to deny Missouri's request did something unusual. They issued a written statement explaining what the denial actually means. Justice Neil Gorsuch authored the statement. Justice Samuel Alito joined it. This was not a dissent. Gorsuch and Alito agreed with the court's decision to deny the stay, but they made clear that their vote rested on a very specific and very limited reading of the district court's injunction. According to Gorsuch, the injunction binds Missouri, its officers, agents, and employees.
And that's all it binds. It does not and cannot bind private citizens who were not parties to the lawsuit. That point changes everything. Federal courts have equitable power to enjoin parties before them. They do not have the authority to issue sweeping injunctions that bind the entire world. That principle was central to the Supreme Court's handling of the Texas abortion law, Whole Woman's Health versus Jackson. In that case, the court held that because Texas had delegated enforcement of its abortion ban to private citizens, there were no state officials to enjoin. As a result, abortion providers could not obtain a pre-enforcement injunction blocking the law statewide. They had to wait until they were sued and then raise constitutional defenses in individual cases. Gorsuch explicitly cited that precedent. He emphasized that any attempt by a federal court to prohibit private individuals from filing lawsuits under Missouri's law would exceed the court's equitable authority. In other words, while Missouri as a state may be blocked from enforcing SAPA, private Missourians are a different matter entirely. This is not a minor clarification. It means the core enforcement mechanism Missouri designed, the private right of action, may still be operational. The state attorney general cannot bring lawsuits under SAPA while the injunction remains in place. State agencies cannot enforce it, but private citizens were never parties to the federal lawsuit. They were never enjoined, and according to Gorsuch and Alito, they cannot be enjoined without a separate legal basis. That creates a profound legal dilemma. Imagine a scenario where a Missouri citizen learns that their local sheriff's department assisted federal agents in enforcing a gun regulation that Missouri's law declares unconstitutional. That citizen files a lawsuit in state court, seeking the statutory $50,000 penalty. The sheriff's department will argue that the federal injunction bars the lawsuit, but under Gorsuch's reasoning, that argument may fail. The injunction binds the state, not the citizen, and the citizen is acting independently, not at the direction of state officials. The federal government would then face a choice. It could intervene in the state court case and argue that Missouri's law is preempted by federal law and therefore unenforceable, but that would require litigating potentially hundreds of individual cases across Missouri's counties. Or it could return to federal court and ask for a broader injunction, one that explicitly prohibits private enforcement. But that raises serious jurisdictional and constitutional questions, especially in light of the Supreme Court's own precedent. This is the same structural problem that plagued challenges to the Texas abortion law. There is no single defendant to enjoin. There is no centralized enforcement authority. Every case becomes its own battle. For the federal government, that is a nightmare. For Missouri's supporters, it is exactly the point. The Supreme Court's denial of emergency relief does not shut down this strategy. It exposes its resilience. Gorsuch and Alito did not say Missouri's law is constitutional. They did not endorse the penalties, but they made something very clear. Federal courts cannot simply wave a wand and neutralize private citizens who choose to act under state law. That clarification transforms this 8-to-1 divide into something far more ambiguous. The law may be frozen at the state level, but its private enforcement heart is still beating. And now, the next phase of this fight moves to a court that may be far more receptive to Missouri's arguments. With the Supreme Court declining to intervene at the emergency stage, the case now returns to where it was always headed, the United States Court of Appeals for the Eighth Circuit. This is where the real fight begins, and it is where Missouri will finally get a full opportunity to argue the merits of its case. Unlike the emergency application, the Eighth Circuit appeal will involve comprehensive briefing, oral arguments, and a detailed examination of the constitutional questions at stake. That process will take time, likely 6 to 12 months, possibly longer given the complexity and national significance of the issues involved. And the Eighth Circuit is not a neutral battleground. It is widely regarded as one of the more conservative federal appellate courts in the country. The circuit covers 7 states, including Missouri, and it has a strong record of rulings favorable to Second Amendment claims. Since the Supreme Court's Heller decision in 2008, the Eighth Circuit has decided multiple major firearms cases, often siding with gun rights advocates at a higher rate than the national average.
That does not guarantee Missouri a win. But it does mean the state will be heard by judges who are deeply familiar with the anti-commandeering doctrine and who may be more skeptical of federal overreach arguments than courts in other circuits. Missouri's core argument on appeal is straightforward. The state will argue that it is not nullifying federal law. It is not preventing federal agents from enforcing federal statutes. It is simply exercising its constitutional right to refuse cooperation. The Supreme Court has repeatedly held that the federal government cannot compel states to enforce federal regulatory programs. Missouri will frame SAPA as an extension of that principle. The state will also argue that the private enforcement mechanism is constitutionally permissible under existing precedent. If Texas could rely on private citizens to enforce abortion restrictions without immediate judicial shutdown, Missouri will argue, then it must be allowed to rely on private citizens to enforce Second Amendment protections. From Missouri's perspective, the federal government cannot selectively tolerate this enforcement structure based on political preference. Either the structure is constitutional or it is not. But the federal government's counter-arguments are serious and potentially persuasive. The Department of Justice will emphasize that Missouri went beyond mere non-cooperation. SAPA does not simply decline to assist federal enforcement, it actively punishes state officials for choosing to cooperate. That distinction matters. The federal government will argue that penalizing cooperation crosses the line from passive resistance into active obstruction. The government will also argue that the private enforcement scheme is a transparent attempt to evade judicial review. By outsourcing enforcement to private citizens, Missouri is attempting to create a system where federal law can be undermined without a clear defendant to challenge. The DOJ will argue that this undermines the supremacy of federal law and invites chaos. There is also the Supremacy Clause problem. Federal law is the supreme law of the land. States cannot declare federal regulations unconstitutional and then impose penalties based on that declaration. Missouri's law does exactly that. It allows state law to override federal determinations and punishes officials who do not comply with the state's interpretation. That argument will resonate with judges who worry about fragmentation of federal authority. If Missouri can do this for gun laws, what stops other states from doing it for immigration, environmental regulations, or civil rights enforcement? That is the question looming over this case. The Eighth Circuit will have to decide whether SAPA is a legitimate exercise of state sovereignty or an impermissible attempt to nullify federal law by other means. That decision will have implications far beyond Missouri and far beyond the Second Amendment. No matter how the Eighth Circuit rules, this case is almost certainly heading back to the Supreme Court. If Missouri wins, the federal government will appeal. A ruling allowing private citizens to penalize state officials for cooperating with federal enforcement would represent a dramatic shift in the balance of power between states and the federal government. Washington would not let that stand without Supreme Court review.
If Missouri loses, the state will appeal. Given the unresolved tension between the anti-commandeering doctrine and the Supremacy Clause, the Supreme Court may feel compelled to clarify where the line truly lies. And when that happens, the court will not be able to avoid the merits. The justices will have to answer questions they sidestepped at the emergency stage. Can states penalize their own officials for enforcing federal law? Can private enforcement schemes be used to insulate state policy from judicial review? And how far does the anti-commandeering doctrine really go? The answers to those questions will shape not only Second Amendment enforcement, but the future of federalism itself. For gun rights advocates, this case represents a bold attempt to use constitutional structure as a shield against federal regulation. For opponents, it represents a dangerous precedent that could undermine the uniform application of federal law. For the courts, it represents a problem they can no longer postpone. The 8-1 vote did not end this fight. It delayed it. And in doing so, it may have allowed Missouri's most controversial strategy, the use of private citizens as constitutional enforcers, to survive long enough to test the limits of federal judicial power once again. This case is far from over. What happens next in the Eighth Circuit will determine whether Missouri's approach becomes a blueprint for other states or a cautionary tale. Either way, the consequences will be felt for years.